As a California personal injury lawyer, I get questions all the time about the legal concept of respondeat superior. This is a Latin term that literally means let the master answer. In a nutshell, respondeat superior means that when a worker injures somebody in the course and scope of his employment, not only the worker, but the employer as well can be held liable. The injured victim can sue not only the worker, but can sue the company that he works for. Let's say, for example, that I own a pizza parlor and one of my delivery guys causes an accident and injures somebody while making a delivery. The injured victim can sue not just the delivery guy, but me as the business owner as well. This is important because the employer is much more likely to have insurance and a deep pocket from which to recover damages. Keep in mind that the doctrine of respondeat superior generally applies only to employees and not to independent contractors. It also only applies when workers are acting in the course and scope of their employment. So it would not apply to the pizza delivery guy who is driving from home to work to start his shift, but it would apply if he's out on a delivery run. There is a gray area when it comes to a situation where a worker commits a crime, such as assaulting somebody during working hours. Technically, when a worker takes it upon himself to assault somebody, he's acting outside the scope of his employment. In these cases, courts have found that the employer should only be held liable if the assault is related to the type of work. So if a bouncer gets too aggressive with a bar patron and knocks him down, that probably would fall within respondeat superior. If you've been injured by someone's employee and you're looking to sue not only that person, but the company he works for, call us here at the Shouse Law Group.